Good day. In this block of instruction, I want to talk with you about actually performing the cross-examination as opposed to preparing to conduct the cross-examination. It builds off of an earlier block of instruction where we talk about conceptually how to put a cross-examination together. This time we're going to focus on the actual conduct of the cross-examination, how you do what it is that you do when you cross-examine a witness. Now, we always want to start and end our cross-examination by going through case analysis. Make certain that there is a clearly defined purpose for each series of questions that you wish to ask the witness. So in other words, for any block that we pull out of that cross, you can tell me why you need to ask those questions. I have control of the witness at all times. Even if the witness thinks that they're in control, in reality, I'm in control. And control comes from the form of the question and the focus of the question. And the details matter. It is in the details that you have power, both persuasively, from a concrete persuasion perspective, from a storytelling idea, and from a control perspective, from a questioning technique. I always organize to accomplish my goals, not the goals of opposing counsel. If I'm going to impeach, there's got to be a reason for it. And then finally, when it's possible, the words that the witness has uttered themselves, either in writing, video, or otherwise, is one of the most effective ways that I have to cross-examine, because the words of the witness have power, and I want to use that power throughout my cross. So, in order to maximize the persuasive impact of the cross-examination, I have to cluster my facts by topic. I've got to ask one fact leading up to a final point, and I want to identify similar facts using them to make that final point. So what I'm doing is I'm thinking of the logical progression that I have to consider whatever the incident happens to be. Let's say I've got a witness who was getting ready to go to work that morning. He's walking to the subway, and while he's walking to the subway, he witnesses a car accident. Now, my cross-examination, clustering the facts by topic, might go something like this. So you woke up that morning, got out of bed, went into the bathroom, took care of your morning business, brushed your teeth, went through your grooming ritual, you got dressed, grabbed your wallet, grabbed your keys, grabbed your phone. Your phone is a smartphone. I believe you have an Android, is that right? You had your phone in your hand, going through your calendar for the day. You're walking to the subway. You're going to get on the loop, you're going to come to work. So you're walking down the street, looking at your phone, checking your calendar for the day. And we know that you were checking your calendar for the day because you sent an email during that time frame. So you not only checked the calendar, you were texting the email. You use your thumbs? You used a stylus to text, okay. So you're texting to someone else, holding the phone in your hand, and you hear something. You hear a crash. You turn to look at the crash. You did not see the accident itself. Now that's a classic example of a logical series of progressions based upon common sense, moving from one point to the next point to the next point, painting a picture that is designed to create certain assumptions on the part of the jury who's listening to it. Also designed, quite frankly, to tell a story of a busy human being on their way to work. Not the type of person who might have been paying attention to the traffic at the moment of impact, which could be important for me. Now, there are 7 things that I need to do as I do my cross-examination. I have to have properly identified the issues, and I would refer you to our earlier presentation on preparing the cross-examination for how you go through that issue identification process. I have to have discovered the story of the case. and not only the story of the case, but how this witness connects to the story. I've then formed the questions, and then I order those questions. I use the appropriate persuasion techniques, and then I plan my physical presence within the courtroom. I think about, before I begin the cross-examination, where I might stand and why I might stand there. And if I'm thinking at a more advanced level, I'm also thinking about how I may also stand in that spot during opening statement or closing argument when I'm talking about this particular witness. I am beginning to bring together the cohesive whole and seeing how the cross-examination fits within the context of the case itself. So that's our checklist. Now, as I think about identifying the issues of the case, I perform case analysis. I look at those hard questions of fact, good and bad facts, and I look at impeachment. And we've talked about that in an earlier block of instruction. But another thing that I do as I identify issues for cross is I listen during the direct. I listen and I gauge the credibility of the witness, the way in which the jury is responding to the witness, how I perceive their demeanor in the courtroom. Because my understanding of their credibility, believability, and demeanor is going to influence the tone, if not the structure, of my cross-examination. And it may be that something happened in direct that was like a gift from heaven, that I now have an area of impeachment that I didn't have before. I now have a good fact that the witness has never admitted before. If I don't pay attention during direct examination, I'm not going to catch that. I'm not going to have that issue, and I'm not going to weave it into my cross. This is why I have to, as a best practice, be prepared for the cross before I ever conduct it. Because I am not only looking at my analysis of the case, I'm also looking at what's happening when the witness is testifying. And then the other thing I have to think about is the other evidence that's in the case. There are other things that have been admitted. There's other evidence that could potentially be admissible. And I want to make certain that as I think of the cross and think of the issues, I'm also looking at what else is out there, both through other witnesses and otherwise. So these three areas are all ways in which we identify the issues. I've then got to find the story of the witness. And I want to find the story of the witness as it connects to the overall story of the case. So I've done case analysis, I've done case preparation, and I've done discovery. I've thought about the story that is present within the case itself, which is, it's just my grabber, if it doesn't fit, you must quit. Where's the beef? Some other dude did it. Whatever the overall overarching theme is, how does this witness's story fit into that theme? Are they the companion? Are they the evil nemesis? Are they the ingenue? Are they the individual who was clueless, who just didn't know what was going on? I have to have a story of the witness that I conceptualize so that I know how it fits into my story. Now, part of that story has to come from the way in which the witness acts when they're on the stand. If I have a story of the witness that is not supported by their tone, their demeanor, and their appearance when they testify on direct examination, I've got a problem. I have to explain why my story of the case doesn't fit their story of the case. And I need to be prepared to properly impeach or cross-examine to expose the person that is hidden. Now, this can be quite effective. The person wants to act like they're just as pure as the day is long, and then we find out, no, actually, they've engaged in this, and this type of behavior that they've hidden from the court. That can be an effective way to tell the story of the witness who's trying to tell another story. Now, as I look at telling stories of witnesses, I'm reminded of one of our other blocks of instruction about various storytelling techniques. Simplicity, unexpectedness, and brevity are very effective ways to push a story forward. Focusing on one thing, boom, 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 in a brief, workmanlike fashion. And then showing the unexpected contradiction that exists. If you'll think about our earlier instruction on storytelling techniques, man, they fall right into line with ways in which you can effectively cross-examine. They fall right into line with the one fact question leading to a conclusion. They fall right into line with this idea that details matter, that concrete details paint a picture that allows the jury to truly determine credibility or the believability of a particular fact. And it's fascinating, if you'll think about it for a moment, that the things used by screenplay writers, by authors, by individuals who are telling stories are exactly the same structural components that we can use for effective cross-examination. And I want to go back and think about those. I want to go back and think about how concrete are the facts that I'm crossing on. How does it contrast with other stories that they've heard? What is the context of what's being said? Because that's going to help you. And then there's an emotional component to what we do on cross-examination, whether it's the emotional relationship between the witness and other witnesses in the case, between the witness and the parties, and sometimes the emotional response to the attorney. I have to be cognizant of the emotion that is within the courtroom, and I have to tailor my questions, my tone of voice, the way in which my voice drops or rises to the moment. Not only the intellectual moment of the fact, but the emotional moment of the room. Because I want the emotion that I showcase in the way in which I ask the question to dovetail, to complement, really, the emotion that I'm trying to create in the jury to get them on my side, to bring them to my theme or theory of the case. So this emotional component is personal, and it creates credibility. And it's very, very useful for me on cross-examination if I understand it. But that means that I've got to know myself, and I've got to understand the witness as well. Now, this is going to require you to make some hard decisions, because sometimes the story that you would like to tell of this witness is not the story that really fits your overarching goal for the trial. And in those instances, less can actually be more. Occasionally, I just have to let go that wonderful series of cross-examination questions that I would like to ask, because while it might be fun for me, it's not going to advance the story of the case. And I have to think about that because less allows me to focus, allows me to use brevity, allows me to use simplicity in a way that's more effective for me. More often than not, a poor cross-examiner snatches defeat from the jaws of victory by going down the road that they did not need to go down for their own personal pleasure. And all you wind up doing is hurting the witness in front of the jury and losing credibility yourself. And in those close cases where the credibility of the lawyer is a key component, you're going to create a problem that you're not going to have an effective solution to. So, how do I do this? Think about appropriate questioning techniques. We've talked about these in other instances, but I want to headline the subject matter that I'm getting ready to talk about. When I get an answer that is just so good, I want to loop it back into the next question. Now, I don't want to do this all the time or I'll sound like I have Tourette's, but occasionally it's so effective. And then I want to couple ideas. I want to couple the ideas from one concept to the next question. So those are the signposts that I use, and they're really nothing more than the planting the flag in the ground, telling the jury this is what I'm asking about. Hey, Mr. Witness, this is what I want to ask you. Hey, Mr. Jury, this is what we're asking you. Hey, Miss Jury, this is what we're going for. Everybody sees the connections. Now, the way in which I do this is I lead. I ask one fact, simple questions, grounded in common sense, building to a goal. Now, what does that mean? It means that I am not concerned with whether or not every single little fact that I ask on cross-examination is contained within the case file. Think of the earlier example that I gave about the cross-examination of the witness who saw an accident or who was at an accident scene. Now, in all likelihood, you're never going to get in the materials of a witness I woke up that morning, showered, shaved, ate breakfast, got dressed, and left for work. But we know human nature. We know that people wake up. We know they go to the bathroom. We know they brush their teeth. We know they pick out their clothes. We know they pick up their wallet. We know they pick up their phone. We know they grab their keys. We know they have a day that they're going to. And based upon our understanding of the case, we can find those common sense facts that we can cluster around the topics that are important to us. And what that allows us to do is to make the topic more believable, to make the topic, the ultimate goal question that we're striving for, more solid. It places it in a place where we are certain that we can effectively move the jury to our point of view. And that's what happens when we use this leading one fact, simple approach based upon our common sense and understanding of human nature, striving towards a goal that we know we want to arrive at. Leading questions establish control. They keep the focus on us, and they keep the witness on the point of the spear. Now, what do I mean by that? I mean the question gives the witness only one way to go without the witness paying a cost in front of the jury. So by keeping them on the point of the spear, they're going to admit the fact that I need them to admit, or I am going to impeach them with a prior inconsistent statement. If they slide in a bad fact, I'm then going to impeach them with bias, motive, or credibility. Leading questions establish control. And we lead most of the time on cross-examination. Now you'll notice I said most of the time. Sometimes it's quite effective to ask an open-ended question. When lawyers ask open-ended questions on cross-examination, it's because there is not an answer that is going to hurt them, or they just don't know what the answer is, and the demeanor in the room calls for the question to be asked, and if they don't ask it, they know it's going to come out on redirect. So open-ended questions can be effective, but only when the cross-examination leading questions coming to the open-ended question have done their job appropriately. Now, many of you may have heard that never ask the one question too many because it's just going to blow up in your face. That's one of those 10 commandments of cross-examination that comes from Irving Younger. It's a wonderful idea and concept, but it's absolutely ludicrous in practice. Why? Because the one question too many immediately comes out of opposing counsel's mouth on redirect. And at that point, it's too late for you to deal with it. So the one question too many is a nice concept, but it's really not something that you should use to drive your cross-examinations. Why do we use one fact? Well, it lets us tell the story. It helps us to control the witness, but most importantly, it helps the jury understand what is happening and why it is important. Now, each and every one of us has had the one fact, the need for the one fact approach driven home to us. Often, it's a painful lesson. I myself am no different. In trial a few years ago, I'm cross-examining a witness with a wonderful impeachment that is tied to a bad fact that they've entered against my client. And it's going so well. I am just ripping this witness to shreds, like bam, 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 bam. I get done, judge alone trial, by the way. The judge says, well, Mr. Rose, I'm pretty sure that was an important cross-examination and that impeachment, but you were asking questions so quickly that I couldn't quite follow it. Would you cover that again, please? Well, of course, Your Honor. Now, I didn't do that on purpose. I had gotten caught in the moment so much that even after years of practicing and teaching this subject, I was overcome with the emotion of the questions that I was asking. I mean, I had the witness that was actually lying, and I had them in my hand. And I was going to show everyone that they were lying against my client. And it was important to the case, and I got carried away. One fact lets you tell the story and control the witness and minimizes the possibility of that occurring. Most importantly, it slows you down so that the jury understands what it is you're trying to do and why it matters, which is really the ultimate goal of cross-examination, unless you're just crossing to try to muddy the waters. In that particular set of circumstances, maybe you'll hop around like a kid who's barefoot on an asphalt road. But there's a different goal that's involved if you're doing that. The logical progression sets up the witness. It implements the goals of case analysis, and it gets the juror there first. Everyone knows where you're going. Now, I don't want you to confuse logical progression with chronological order. The logical progression comes from the topic of the goal that you're trying to achieve. So in the headline you say, Mr. Witness, I want to talk with you about what you saw on the morning of October 5th. There's my headline. We're talking about October 5th. Now maybe my goal question is, you didn't really see anything. Or my goal question is, you didn't see what you thought you saw. But I've established the headline, and then my questions go in a logical progression so that by the time we get to, you didn't see anything, or you didn't see X, the jury already knows what's coming. And the witness knows what's coming, and the witness has a choice to make at that point. Do they agree with me and admit that perhaps they were mistaken, or do they just look like they're being contrary and fight me on it and lose credibility in the eyes of the jury? Think of My Cousin Vinny and the Magic Grits cross-examination. Classic example of facts leading to a point that once we saw it, everybody knew what was going on. So how do we do this? How do we do this in an effective fashion? Let's pull that slide out. I want to avoid the structure used on direct, begin and end powerfully, connect to the theme and theory. Impeachments must matter or I don't do them. I organize to tell my story. And when I impeach, it's got to be important. I've got to do it at the right time and in location, location, location. I impeach where it does the most persuasive good for me, not for the opposing side. I mean, the overarching thing here is that you must organize the topics of your cross in a way that tells your story of this witness, not your opponent's. And the most common mistake that is made is to cross-examine based upon the direct testimony in the same chronological order, and all you're doing is reiterating the lies that were told on direct examination. You might as well not do anything, which in fact sometimes, when I have a witness who hasn't hurt me, can't give me a good fact, might perceivably have some bad facts that weren't brought out, occasionally the best cross-examination is no questions, Your Honor. Why? Because when I have no questions, opposing counsel doesn't get to do a redirect. So, when I go after fact-based cross-examinations, to get out the good facts, I like to bring them up front. I like to time them and connect them to direct, and I want to use a tone and demeanor that is agreeable. That says, Mr. Witness, there are some things perhaps that we can agree about. Let's talk about some of those, all right? We agree X, we agree Y, we agree Z. You agree to this, you don't contest this, you don't contest this. In fact, you yourself have said all along, all of these facts are true. Thank you. I appreciate your honesty. Now, on the other hand, if I'm dealing with bad facts, if I'm looking at those, I've got to have control of the witness before I get into the bad fact. And control of the witness can come from an impeachment. It can come from a prior inconsistent statement. It can also come from my tone and my demeanor. You're John Smith. You live at 1314 Runaway Avenue. You're 28 years old. You work for ABC Construction Company. You were working for them in June of 2008. You were a laborer. You were present when your boss had a heart attack. Whatever it happens to be. I change my demeanor to get that control. And I always connect the bad facts that hurt me to a run of impeachment that attacks the credibility of the witness. Organization, again, to tell your topic, is the important component here. Now, how can we use persuasion to effectively impact our cross-examinations? Well, I want to begin by identifying those trigger points. And by trigger points, I mean those things that once the jury hears them, they're going to make certain assumptions about the witness that impact on their credibility. Classic example, if you look at the O.J. Simpson trial, the use of the N-word by Mark Furman. That created a trigger point that Mark Furman was a racist and his investigation could not be trusted. We saw the use of trigger points psychologically in the Zimmerman trial in Florida here recently. The use of certain epithets by Trayvon Martin created certain thought processes, arguably at least in the mind of the jury. I also want to use that contrast principle. When I've got something that the witness has said and I can contrast it to something else that they said and the two don't seem to go together, I can reduce the believability of one or increase the believability of the other. So contrast helps, and contrast and comparison are very, very helpful to us. And we've also talked about reciprocation followed by consistency. Members of the jury, you promised me that during the course of this trial you will X, Y, or Z. That's a promise that is made. I promise you that I won't waste your time, or I won't do this, or I won't do that. And then I act consistent with that promise throughout the course of the trial. It's much more likely that the jurors will act consistent with their promise during deliberations. Same thing happens when dealing with a witness on cross-examination. And it's very interesting. Once I can get a witness to commit to a particular fact or a particular version of events, they are then going to testify consistently with that commitment for subsequent questions. So I can, once I pin them down on one thing, if I can connect additional questions to the thing that they've admitted, I've got them. Because now I can use that commitment to create consistency. And I want you to go back and look at the commitment devices that we discussed in our earlier presentations on persuasion. The one that's of particular interest from a trial perspective is this idea of writing things down. Suddenly using a witness to go to a chalkboard to write a list or to use a diagram takes on an entire different psychological aspect. Because by having made the writing, they're more likely to act in a fashion consistent with the writing. That's fascinating. These persuasion techniques from Influence, the Psychology of Persuasion by Robert Cialdini have some really interesting applications when I format and structure my direct and cross-examinations. So, storytelling also applies here. The concepts of simplicity and brevity and consistency should permeate the logical progression and structure of my cross-examination runs. I want to have context for the questions that I asked, and then occasionally I want there to be contrast or novelty and surprise that brings us back to the purpose of the cross. Every piece of the story of the cross-examination has to be essential. And I want to use questions that appeal to the senses. Details do this. The sound of the traffic, the smell of the street, the taste of the berry on your tongue. These details create a psychological re-experiencing on the part of the listener, and it makes the cross more believable. Remember to end strong. You want to keep your promise of trust and let the listener solve it for themselves. This is mentioned in a storytelling lecture that I had you guys watch on TEDx off of YouTube by a guy named Andrew Stanton. He talked about the difference between telling the jury what is 2 plus 2, or he says the audience, asking the audience what is 2 plus 2, and telling the audience 2 plus 2 is 4. Your story says what is 2 plus 2. The jury says the answer is 4. That difference from a storytelling perspective is phenomenally useful because it lets the listener solve the story themselves. And people always feel smart when they solve the story first. They enjoy that, they like that, and they come back to it again and again. And that's a technique that you really ought to think about as you prepare your crosses. Last thing that we'll talk about today is your location within the courtroom. As I think about where I stand on cross, well, if I'm in federal court, of course, the judge is going to try to tether me to that podium because they're afraid of what I might do if I get away from it. but even then I can move from side to side. Location matters because I want my movement tied to my questions. If I'm in a state court or a court that allows me to move around the courtroom and I have a series of questions leading up to a dramatic moment, a goal question, I'm going to ask a question, get my answer, move a little closer. Ask a question, get my answer, move a little closer. Because I am creating the psychological feeling that this answer is valid and this is important. And I'm doing it without threatening the witness. So if you're my size, you might not be able to get closer than 10 feet. If you're somewhat more petite, maybe you can get a little closer. I don't have that option. Now, as I think about all that we've talked about today, this organization and the presentation of the cross, if we focus on logical goals with a methodical progression, we'll let the jury get there first. If we focus on the 2 plus 2, the jury will get to the answer of 4. My cross needs to come back to the theme of the case that I've talked about. And all questions need to lead to the goal question. It's like I'm climbing a series of steps, and by the time I get to the end, the jury has no choice but to know what the answer is, and the witness has no choice but to admit what the answer is that the jury already knows. Because if I'm doing 2 plus 2, and the jury knows the answer is 4, and the witness says that the answer is 5, he's like the turkey in the oven in Thanksgiving. His butterball timer is popped out, and it's time to take him out of the oven because the cross is done. Now, we've talked about these concepts of cross-examination. I hope that you've enjoyed them. I hope that you're thinking now about how our earlier classes on persuasion techniques and storytelling truly do connect to specific advocacy skills. Make certain that you check our discussion board for your assignment, and we'll be talking to you later.